Okay, thanks everyone for joining us, and hope you've got something to eat. Make yourselves comfortable. Use the chat function along the way, or hopefully we'll have a few minutes at the end for you to join in with questions or comments. But today we are here to talk about mandatory vaccinations. There's plenty to talk about in terms of COVID-19 issues in the workplace, but very much focused on the mandatory vaccines issue. And of course, all the information is just up to date, up to today, but this is a moving feast, everyone. There are new things and new developments happening all the time. So over the next few weeks, you will have to keep your eye out and see what other further updates happen beyond today. So my name's Gabrielle Marchetti and I'm Principal Lawyer at JobWatch, and I'm delighted to have you all here for this presentation. We, of course, acknowledge the traditional custodians of country throughout Australia in the spirit of reconciliation. We acknowledge their connections to land, sea and community, and we pay our respect to Aboriginal and Torres Strait elders, past and present, and we extend that respect to all Aboriginal and Torres Strait Islander people today. So the big question for everyone is, can employers in Victoria require employees to be vaccinated? That's why you're all here. And of course, you've seen many headlines over the last few months. I've only just put in 2 headlines from a little while ago relating to Qantas introducing mandatory vaccines, and SPC up around Shepparton, being our food processors, and of course those announcements were fairly controversial at the time. There have been plenty of other announcements, but I just want to set the scene and give everyone some context. So we have all been told across Australia that our federal government policy on vaccines is that vaccines, COVID vaccines, are voluntary and free. So they are voluntary. No one is allowed to pin someone down, physically hold them down and force a jab into their arm. However, as is stated on the Department of Health website, the Commonwealth Department's website, there may be circumstances where proof of vaccine may be required. It might be a precondition of employment in particular areas. So for example, we've all known for a while now that for anyone working in a residential aged care facility, there have been public health orders in place across Australia. So these are things that have been agreed to by all the various states and territories, and then each state and territory has implemented its own public health orders. So outside of the public health order domain, we have also had a number of private sector employers who have mandated the vaccines, and so I've listed some of those examples there. Now, in terms of how I think everyone should approach these questions, whenever you're thinking about whether you or your friends or people you know can resist an employer direction to be vaccinated, the starting position should always be that most employers are not simply, they don't have any right as such to require employees to be vaccinated. So there isn't a law, it's certainly not in the Fair Work Act, for example, that all employers must or do have this right, do have this entitlement or obligation to require all their employees just as a black and white sort of rule. However, there are always many exceptions, and the 4 main exceptions that you then have to turn your mind to in order are the ones listed in that second column. So you may be obliged to get vaccinated if you want to continue your job or if you want to start a new job, if, number 1, if there is a public health order in place. And of course, I'm going to be focusing on Victorian public health orders today. Number two, you might be obliged to be vaccinated if the requirement is permitted. So if your employer is allowed to rely on a clause that is in your employment contract or an enterprise agreement if you're covered by one. So you'd have to have a look to see what are you exactly covered by. Are you covered by an award or an enterprise agreement? Are you covered by an employment contract that's in writing? Do you have internal policy documents that apply to you, to your employment? If so, check those written documents very carefully to see if the employer can rely on something that is in writing in one of those documents. Number three, your employer might direct you to be vaccinated by a certain date, and they will be allowed to rely on that direction if the direction is lawful and reasonable. And the important thing here, everyone, is that this is always going to be assessed on a case-by-case basis. So there's no one direction that is lawful and reasonable across all workplaces. It will always have to be assessed on a case-by-case basis. And before we go on here, I want to make the point that all employees have an implied duty. So this doesn't need to be in writing. We all have an implied duty to obey our employer's lawful and reasonable directions. That's just implied at law. Of course, the million-dollar question, the thing that keeps lawyers in jobs very busy, especially at the moment, is whether or not the direction is lawful and reasonable in the circumstances. But you need to think about that, and we're going to be talking about it more in a sec. And the fourth exception that you need to turn your mind to is whether or not your employer might be able to rely on an argument that it is actually an inherent requirement of your job to be vaccinated. And therefore you can't, if you're not vaccinated, you can't perform the inherent requirements of your job. Now, the reason that I've broken those last two things up into two separate considerations, you know, whether it's a lawful and reasonable direction and whether it's an inherent requirement of your job, is because if you think about in lots of cases, think it through. If you refuse, you're already working, you're already employed, and you may be eligible for unfair dismissal. So you might, if you're protected by the unfair dismissal laws and you refuse to be vaccinated, in many cases, what will then happen is that your employer may then go ahead and dismiss you. And the dismissal, if you're going to go down the path of lodging an unfair dismissal claim, one of your arguments in saying that you have been unfairly dismissed is the starting sort of argument is always, I don't believe that my employer had a valid reason for dismissing me. Now, your employer does have a valid reason for the purposes of an unfair dismissal application. Your employer does have a valid reason if that reason is based on conduct or capacity. And that's why I've divvied these two things up, because conduct, if your employer is saying this dismissal is justified on the basis of conduct, what they're really saying is this employee, we have found them to be guilty of misconduct. They have disobeyed our lawful and reasonable direction. And so we're going to be considering that more fully in a second. The second one is capacity. They might say, we are justifying the dismissal on the basis of incapacity, i.e. we believe that this particular employee is incapable, does not have the capacity to perform the inherent requirements of their job. So they're two separate considerations. Now, even if you think you might fall within one of these situations here, where maybe you do have to comply with a direction to be vaccinated because of one of these reasons, of course, you must always still consider whether any anti-discrimination laws apply and protect you. And if they do, perhaps you can go down the path of making a discrimination complaint through one of our bodies, and consider whether your employer has complied with any requirements to consult with you and all the rest of the workforce. All right, so let's go through each of those 4 in turn. So firstly, I'm of course focusing on Victoria. So we have had a number of Chief Health Officer directions, and you can all look these up on the Victorian DHHS website. They're all listed there, they're all provided in both Word and PDF versions. But just to summarise, we have previously had, over the last few months, we've had Chief Health Officer directions in place that have covered all frontline quarantine workers and all residential aged care workers and all construction workers. And I'm sure you already know about these categories of workers because they've already been in place for a while now. The latest direction in relation to employment came into operation last Friday. So these directions commenced on the 7th of October, and they are actually issued in 2 separate statements or 2 separate documents that you can find. I've given you the names there if you want to look them up, but I am going to, I've also just listed at the bottom of this slide that actually, if you want to be technical, the most recent directions commenced on the 9th of October, but they're not in relation to employment. They're in relation to obligations on businesses that provide goods and services to the public. Okay, but so I'm focusing on employment, of course. So on this next slide, you can see who these latest directions apply to. So they've basically extended all the obligations that we already had in place for residential aged care workers and construction workers. Those obligations have now been extended to healthcare industry and to the education industry. So these workers, and there's definitions of exactly which workers in these industries. I've given you who they include, but if you want to look up the extended definitions, of course, you'll need to look up those particular documents. They include all full-time, part-time and casual workers, and they also include students on placements that go into these settings and volunteers as well. So very broad definitions of workers. And you can see there the different dates. So in terms of healthcare workers, the first vaccine has to be done by the 29th of October, second vaccine by the 15th of December. In the education sector, which of course includes not only primary and secondary school teachers, it's much, much broader than that. It extends to childcare and early childhood workers, etc. And the dates that are relevant there are that the first jab has to be done by the 25th of October and the second one by the 29th of November. Now, in the second document that I referred to everyone, and I'm just coming back a slide because I want to refresh your memories, it's the second last bullet point that I've written there, COVID-19 mandatory vaccination brackets workers directions. So according to those directions, a whole lot of workers, it's a whole list of prescribed workers, and I've given you the whole list there. Basically insert the word workers after each of the categories. So you've got all these different categories of workers will have to be vaccinated according to this Chief Health Officer direction. The first vaccine has to be done by the 22nd of October, so end of next week, and the second vaccine by the 26th of November. And you can see it's a really broad list of workers across Victoria, including retail. So all retail workers will have to be vaccinated according to this Chief Health Officer direction. There are also other obligations on employers that are imposed by these Chief Health Officer directions. So as soon as reasonably practicable, which is always one of those wonderful legal terms, employers must notify all the workers in their workforce who are required to work outside of their home. So if I'm a worker, coming back one slide, going back to this list, if I'm a worker, for example, in community services, I'm a community services worker, or I'm a retail worker, or I'm a social and community services worker, any worker that fits into this category, I must and I'm required to work outside of my home beyond the 15th of October, which is just the end of this week, from Friday onwards. If I'm expected to work at a different premises, which is not my home, then I have to give my employer proof that I have been at least booked in for my first vaccine by the relevant deadline. So you can see here that employers now have these obligations to tell workers that they will need to collect, hold and store information about vaccine status. And this is, so of course we know, because at JobWatch we have a telephone information service for workers across Victoria and Tasmania and Queensland, and we are inundated with calls at the moment relating to not only directions about being vaccinated, but also queries from people about whether or not they have to give evidence to their employers relating, showing basically proof of the first vaccine. And yes, you can now see that in some cases, it is because of these Chief Health Officer directions. Of course, if you think that you are being asked by your employer to give information about your vaccine status and you don't fall within these categories of any of these workers who are covered by these Chief Health Officer directions, then you certainly can ask more questions of your employer, and you can try and find out why are they asking you for this vaccine information, because your understanding is that you don't fall within any of these prescribed categories. So from the 15th of October, which is Friday, from Friday onwards, employers cannot permit unvaccinated workers to work outside of home unless they've got their first booking by the following week, by the 22nd of October, unless there's an exception that applies. And so here we always, that again, lawyers always deal with exemptions and exceptions. They keep us very busy. So if someone has a medical contraindication, and that is defined, there is actually a legal definition of what a medical contraindication is. Again, you can find the definition on these Chief Health Officer directions. But if you do have a medical contraindication, then you've got to give evidence from a medical practitioner to your employer that you have an exemption. And I've given you the list in brackets of who is considered to be a medical practitioner, because it's not anyone. The other main exception is if you are a worker who has been told that you've got to work off your, outside of your home beyond the 15th of October, and you may not be vaccinated yet, but you are being required to go and do something that is essential. It's essential work to protect health and safety, or it's an emergency of some kind. In those situations, you and your employer are protected under the Chief Health Officer direction. Now, everyone, let's have a look at a practical example of how this might all play itself out. And we're getting lots of calls along these lines at the moment. So Natalia is a retail worker who doesn't wish to take a COVID-19 vaccine because of her religious beliefs and her general skepticism of the vaccine. Natalia's employer has told her that she needs to have the first vaccine by the 22nd and that she will need to show evidence that she's been booked in for the first vaccine. She'll need to give that evidence to her employer by the 15th of October, so by Friday. And she has been told that if she refuses, there's no redeployment option for her, so they can't allow her to work from home. There is no redeployment option for her in her situation, so she will lose her job. And Natalia's employer has said that it's complying with the government direction. Now, of course, we've been told that she's a retail worker. So we all know in terms of those, remember I've said to you, I recommend that whenever you're dealing with any of these issues, you come back to the default is there isn't any outright entitlement for employers. However, is there a public health order in place? Yes, there is. There is a public health order at the moment in Victoria, which extends to retail workers. And we know that because of this list that I gave you here. So the first vaccine for retail workers will have to be done by the 22nd of October. Does Natalia have, if we look at the exemptions, does Natalia have an exemption that is based on her having a medical contraindication? Does she have evidence from a medical practitioner? No, there's no suggestion of that in this example. Because we're only told that she doesn't want the vaccine because of her religious beliefs and her general scepticism of the vaccine. So in terms of the employer being able to stand firm and insist that if she wants to continue working beyond the 15th of October, she's going to have to give evidence that she's at least been booked in to have her first jab. She'll have to give the evidence by the 15th and she'll have to be booked in for the first jab by the 22nd of October. And it would seem that the employer will certainly be able to rely on the fact that there is a Chief Health Officer direction in place. Of course, the law gets very interesting when you start thinking about specific case scenarios where, you know, Natalia might be an employee who's been there for a very long time, several years. Let's say she's been employed for 10 years with this particular employer. She's never taken her long service leave. So she might actually now say, you know what, I would like to access my long service leave at the moment and let's reconsider all of this at the end of my long service leave. Now that would therefore prevent, you would have to think, prevent the employer from going ahead and dismissing her. So these examples, I want you to just work through what the issues are, but of course, remember that it's always going to be a case-by-case assessment of what an employee can do, what you as employees can do in any given situation. Certainly here, it would seem that she does fall within the Chief Health Officer's directions that have been issued. So yes, at first blush, she will need to comply, but depending on her circumstances, she may be able to go on some paid or unpaid leave for that matter. Perhaps her employer may agree to give her some time unpaid leave and then reassess the situation in a couple of months' time. Oh, and of course, finish that off because I've mentioned that, you know, she's got religious beliefs that are holding her back from having the vaccine. She may also, of course, consider a discrimination claim. We'll talk about that further along. But under the anti-discrimination laws that we've got both in Victoria and across Australia federally, there are protections in place, but whether or not she would succeed, so if she's dismissed and then she wanted to argue that she had been discriminated against on the basis of her religion, you know, I'm really not sure that she would have a strong case at all. But that is all, it remains to be seen because we haven't had any test cases yet. So Remember that the first exception that I want everyone to consider is whether or not there's a Chief Health Officer direction in place. The second one is if your contract, your employment contract or your enterprise agreement actually provides for or gives the employer a right to insist on you being vaccinated. And of course, here I should mention that particularly for employees who have only just recently started employment, new employment, or you're about to start new employment within the next couple of months, I would imagine that more and more employers, particularly larger employers who are getting legal advice about their employment contracts, that they will be putting clauses into employment contracts requiring staff to be vaccinated. And so more and more in the future, more and more employees, new employees who are covered by new employment contracts will have these kinds of clauses in their written contracts. Enterprise agreements also, there are enterprise agreements around that do allow the employer to insist on vaccines. You, of course, the devil is always in the detail. You've got to read the clause very carefully because those clauses might have been drafted with the flu vaccine in mind, but they may, in terms of how they're drafted, they may not be specific to flu vaccines. They might in fact give the employer a broad right to insist on a whole lot of different vaccines. So then you'd have to see and consider whether or not that extends to the COVID vaccine. I've mentioned here that, of course, in the middle bullet point, you should always keep in mind any written policies that apply in your workplace and consider whether or not they have been incorporated into your employment contract. So whether or not the employer can insist on you being vaccinated if that is in a policy document. And always keep in mind the anti-discrimination laws. Now, the third exception is that you must consider whether your employer has issued a direction that is lawful and reasonable. And in terms of a direction being lawful, I think there's a lot of misconception around about what does it mean for a direction to be lawful. It doesn't actually have to be, it doesn't have to be consistent. Or sorry, I should say, in order for it to be lawful, it simply needs to not be contrary to any existing laws. Okay, so the question is, if an employer has issued a direction, in terms of considering this first aspect of it, is the direction lawful? Well, then the right question for you to be asking is this direction contrary to any existing law, for example, anti-discrimination laws? If I don't think it's contrary to any existing laws, then it's lawful, okay? And the second aspect of it, in terms of whether the direction is reasonable, now that is complicated because what's reasonable, as I'm sure you all know, will always depend on the facts of the case. And no two fact scenarios are ever going to be the same. So you do have to be very specific about what's the context of the case that you're dealing with. So just remember again, as I mentioned before, all employees, we all have a duty to comply with our employers' lawful and reasonable directions. And if we fail to obey and we don't have a good excuse, then that can amount to misconduct and that can justify dismissal for the purposes of an unfair dismissal claim. So let's have a look at the first decision that I want to consider. These decisions that I've listed are in the context of the flu vaccine. We still haven't had any test cases in the unfair dismissal jurisdiction that have focused on the COVID vaccine. These are all in relation to the flu vaccine. So This first decision that I'm looking at of the Fair Work Commission, it came out on the 26th of May of this year. And basically you had a healthcare assistant, Maria Corazon Glover, and she had been employed for a number of years, and she had every year declined to have the flu vaccine. But all of a sudden, and that had always been fine, the employer had allowed her to decline and to continue working. But all of a sudden, the employer announced that the annual flu jabs were now going to be an inherent requirement of her job as a care assistant. And in doing so, the employer relied on the Queensland Chief Health Officer's directions that were in force at the time. And that was in relation to people not being allowed to enter a residential aged care facility unless they had been vaccinated, with the flu vaccine. So this particular employee was 64 years old. She'd been working there for more than 10 years. And she said, look, every year, you know me, you know already that every year for the last 10 years I've been declining it, and I'm going to decline it again this year because when I was a kid, my parents told me that I could have died because I reacted badly to a shot that I had when I was 7. And she did give her employer a medical certificate stating that she couldn't be vaccinated because she'd had anaphylaxis when she'd had a flu shot back as a child. And she said that basically she didn't think she should attend work until after the flu infection season was over. And the employer didn't roster her and didn't allow her to enter the premises. And she did go on a whole lot of leave, paid leave, but then when that ran out, she was put on unpaid leave, and eventually she claimed that she had in fact been dismissed without a valid reason and without a fair process. So that's how she was arguing her unfair dismissal. Now, the Fair Work Commission here, and it was decided by Commissioner Hunt, decided that the requirement that client-facing employees needed to get the flu vaccine was a lawful and reasonable direction, and therefore her unfair dismissal application failed. Commissioner Hunt said that her role as a care assistant was not that of a widget maker, was not that of a widget maker in a widget factory where her status as an unvaccinated employee might not matter. In that scenario, said Commissioner Hunt, it might be lawful for a widget factory employer to mandate influenza vaccines for widget makers where no such government directive had been made. However, it might not be, or is not likely to be, reasonable in all of the circumstances. So basically, Commissioner Hunt was trying to explain the difference between when something is a lawful direction and when something is a reasonable direction. And in this particular case, Commissioner Hunt decided that this was the kind of position where the employer's direction was indeed both lawful and reasonable in the circumstances, and therefore the unfair dismissal application had to fail. So, what are the key takeaways of this decision? Well, in terms of asking yourself and answering the question of whether a particular direction is going to be lawful and reasonable, this is always going to be a matter of fact. It has to be decided on the facts, and it will always depend on the individual circumstances of the case. And the Fair Work Commission is always going to consider all of the surrounding circumstances to decide whether or not the direction is a reasonable one. Now, remember that I also said that you need to consider, quite apart from whether it's a lawful and reasonable direction, and therefore would you be, would your employer be able to dismiss you on the basis of your misconduct. Apart from that, you also need to consider whether or not they might be able to dismiss you if you refuse to be vaccinated based on the inherent requirements of the job. Because remember that if you can't perform, if your employer says you can't perform the inherent requirements of the role, then your employer may be able to show that they have a valid reason for dismissing you based on your capacity. Now, the Fair Work Ombudsman on their website, they've specifically said that vaccines or vaccination is unlikely to be an inherent requirement in many cases, and certainly not across the board. Okay, so there'll have to be special circumstances in order for your employer to justify that the vaccine is an inherent requirement of your particular job. And again, the guidance that we might have about this question comes from cases that have been decided in the context of the flu vaccine. So this decision here of Barber and Good Start Early Learning, this is a decision also from earlier this year from the Fair Work Commission. This was Deputy President Lake who decided this on the 20th of April of this year. And here we had the employee who was a lead educator in an early, in a childcare facility, and she'd been an employee for 14 years, and she had 14 exemplary years of service, it was found. The employer introduced a new policy requiring all employees to have the flu vaccine. And this employee said, look, I've got a sensitive immune system and I've had a prior adverse reaction, so I'm not going to have it. I'm refusing it. And she was then dismissed, and therefore she went ahead and made an unfair dismissal application. Now, again, the Fair Work Commission in this decision held that her dismissal was not unfair. So basically her unfair dismissal application failed. And the Deputy President Lake here said, look, the reason that I'm going to decide that this unfair dismissal application fails is because I believe on the facts, on the evidence that I've considered, I believe that the employer had a valid reason based on misconduct. So now this is interesting because I've added this decision under the issue of inherent requirements of the job. And the reason that I've put it into this section is because that's actually what the employer argued as their defence. The employer kept saying throughout this unfair dismissal hearing that the reason that they were relying on to dismiss her was that they believed that the flu injection was an inherent requirement of her job. And Deputy President Lake disagreed with the employer. So Deputy President Lake actually said, look, it's very unfortunate that the employer ran its defence in this way and basically put in thousands of pages that was very time consuming for everyone of evidence trying to justify that it was an inherent requirement of the job, because I disagree. I don't think it was an inherent requirement of her job. However, I still do think that the employer had a valid reason, and the valid reason was based on misconduct, not capacity, but conduct. So they did have a valid reason based on the fact that she didn't have a medical basis for refusing the flu shot. And Deputy President Lake found in this particular case that she had been disobedient. So she had disobeyed a lawful and reasonable direction. But interestingly, for everyone who's listening to this, it was not, in fact, an inherent requirement of the job that she had to be vaccinated in order to continue working as a childcare worker. Okay, so very interesting decisions coming through that we can, of course, extend by analogy to the COVID context. Now, here's another very interesting decision. This one you might have all heard a bit about because recently it went, so I've given you 2 citations if anyone does want to look these decisions up. There are 2 decisions around Kimber and Sapphire Coast Community Aged Care. The first citation that I've given you was the first decision that was handed down on the 29th of April of this year. And then the second citation is it went to appeal to the full bench of the Fair Work Commission. And basically in both cases, both times, the Fair Work Commission agreed with the employer that the dismissal was not unfair. So it's another unfair dismissal application that failed. And the reason I say that you might have all heard about this recent appeal is because there was a dissenting judgment from Deputy President Dean, and I believe that it has been going around on social media, and lots of people have been commenting about this particular dissenting judgment, but it is only the dissenting judgment. So the majority of the full bench agreed with the original decision, which is that the dismissal was not unfair because it was in fact part of the employee's inherent requirements of her job as a receptionist working in a nursing home. It was a requirement, an inherent requirement of her job to be vaccinated with the flu vaccine. Okay, that's what was decided on the facts in this case. So here you had the employee who'd refused to be vaccinated. She said, I've previously had an allergic reaction, that's why I don't want to be vaccinated. There were New South Wales public health orders in place at that time that no one must enter a residential aged care facility without having an up-to-date flu vaccine. And as I've said, the Fair Work Commission here did agree with the employer that it was an inherent requirement of her job to be vaccinated. And so again, in terms of the takeaways from these decisions, really, if there is no law and no government direction preventing an employee from doing their job without being vaccinated, then it's unlikely that vaccinations will be held to be an inherent requirement of the job. However, obviously, where there is a Chief Health Officer direction, it may make it much more likely that it is in fact an inherent requirement of the job. Okay, so quite apart from whether or not it's a lawful and reasonable requirement, you also do need to consider whether it's an inherent requirement. That's an extra argument that your employer may have. Now, as I've said, and I'm conscious of time, so always consider state and territory, of course, and federal anti-discrimination laws. We've got, of course, in Victoria, we've got the Equal Opportunity Act, and it protects you from discrimination in employment and a whole lot of other areas of public life, but I'm focused on in the area of employment. But you've always got to be able to show, you've got to link your unfavourable treatment or your discrimination, the discrimination that you're facing, you've got to show that that discrimination is based on one of the protected attributes. So that's one of the protected characteristics. And we've got a whole lot of protected attributes, you know, such as disability, age, race, sex, etc. But certainly vaccine status is not a protected attribute at the moment. So you're not going to be able to make a claim under any of our state or federal anti-discrimination provisions saying that you have been discriminated against on the basis of your vaccine status, because that's just not one of the protected attributes at the moment. You might be able to argue, so for example, under our Equal Opportunity Act here in Victoria, you might be able to go to the Victorian Equal Opportunity and Human Rights Commission and if you make a complaint at the commission stage, they can certainly try to organise a conciliation conference for you to try to resolve your matter informally with your employer. But failing that, if you don't manage to resolve it with your employer, you can then take your matter over to VCAT, which is the Victorian Civil and Administrative Tribunal, and you've got 12 months from when you think that you were discriminated against within which to lodge your complaint at VCAT. And you can try arguing that you've been discriminated against on the basis of some of these other attributes that are in fact protected. For example, the religion one that I said before in Natalia's case, or political belief or political activity. But political belief and activity, everyone, has been interpreted narrowly in Victoria. So, you know, this is all just going to be very much a lookout for updates space, because we're all waiting to see what VCAT, our Victorian Civil Administrative Tribunal, or the Federal Circuit Court or the Federal Court, if discrimination cases come through the federal laws, they will go to the Federal Circuit Court or the Federal Court of Australia, or tribunals in other states and territories. We're waiting to see what decisions come out in the context of COVID, but we haven't had any just yet. So you can, I've confirmed on this slide that vaccination status is not currently one of the protected attributes. If an employer says that the vaccine is mandatory, it's a mandatory condition of continuing your employment or of starting your employment in a particular workplace, you might argue, I mean, of course, you should consider whether this argument is applicable to you, if it's relevant to you, that there's any kind of disability discrimination, if there's a reason why relating to a disability. And disability, everyone, is defined very broadly, remember. For the purposes of a disability discrimination claim, you don't have to be on any kind of disability pension. It could be a temporary disability. And of course, consider any other protected attributes. And if your employer is not making reasonable adjustments for you and is not making an exception, as they should be, of course, it's always about whether or not they're complying with the anti-discrimination laws. But if you believe that they're not, so if we stick to the example of disability discrimination, if you feel that you've got a disability and that's the reason why you can't comply with a direction to be vaccinated, and you've tried to have a conversation with your employer about that, but they're just, you know, putting the hand up and not wanting to listen and not budging and not making any kind of reasonable adjustments for you, and you believe that you know, have made some suggestions to them about reasonable adjustments that could be made, then of course you should consider going to the Victorian Equal Opportunity and Human Rights Commission, or going to VCAT, or going to the Australian Human Rights Commission under the federal laws with a claim. Now, however, in terms of disability, I want everyone to understand that your employer is allowed, so they can lawfully discriminate on the basis of disability or physical features for that matter, but let's focus on disability, if the discrimination is reasonably necessary to protect the health and safety of any person or of the public generally. And yes, the employer will have the onus, so they'll have to prove how this health and safety exception applies in your particular case, but I do want to make you aware of that. So I also said at the start of this presentation that even if you think that your employer might have grounds to insist on you being vaccinated by a certain date because of the Chief Health Officer directions, or because it's in your contract or enterprise agreement, or because it's a lawful and reasonable direction, or because it's an inherent requirement of your job. So for any 4 of those reasons, Still, you should consider, you should turn your mind to whether or not your employer has in fact complied with any requirement that they consult with you. So most workplaces are going to be covered. So you as employees will be covered by a modern award or an enterprise agreement or some other registered agreement. And almost all modern awards and enterprise agreements have a consultation clause. So it's really important to look it up and to see, again, as I said before, the devil is always in the detail. You want to see exactly how is it worded, exactly what is the obligation on your employer to consult with you in terms of bringing in any significant workplace change. And of course, you would argue that bringing in a requirement that all employees must be vaccinated, or certain employees, and you fall within that categories, have to be vaccinated by a certain date, you would argue that that's a significant workplace change and therefore the employer should be consulting with you. And if they don't consult with you, then of course you need to think about what action can you take, and are you prepared to take action against your employer for breaching that modern award or that enterprise agreement. Okay, I'm not going to read through these again because I feel like I've said them many times. Just always go through the steps and think about whether any direction that your particular employer has issued falls within one of those 4 categories. I've listed them all here, and even if they do, still consider the anti-discrimination laws and whether or not you can go ahead and make a discrimination claim to one of our agencies here in Victoria or federally, and also consider the consultation and whether or not your employer has complied with any obligations to consult with you. Now, that brings us to the end of this presentation, and I'm very happy if you have questions. I'm going to try to answer your questions as best I can, but I do want to just end on this note. JobWatch is a community legal centre, which I'm sure that you all know, and that means that we are not part of government. We're not a statutory body. We are a not-for-profit organisation. We have a large number of resources, written resources on our website, and of course we encourage you to jump onto our website, which is jobwatch.org.au. You'll see Q&As on the front page, on our home page, relating to COVID. But apart from the Q&As about COVID, if you go in the section, if you click on resources, you will see a whole lot of fact sheets that are all listed in alphabetical order about a whole lot of different topics that are employment related. And of course, everything is about protecting employees, okay? We're not here to double up with unions, so we are here to basically fill the gaps for people who are not union members and who cannot afford private legal advice and private representation. You've got the phone numbers there. We've got a Metro Melbourne phone number, and we've also got a number for people calling from outside of Metro Melbourne, so that's the 1-800 number. Down in the left-hand corner, I've put in red my email address and our phone number, which is not the JobWatch telephone information service. So please only use my email address or that other phone number in red if you work in a community legal centre or in another one of our partner organisations, so any of the statutory agencies, for example, legal aid officers, VORC, Victorian Equal Opportunity and Human Rights Commission, Australian Human Rights Commission, Fair Work Commission, Fair Work Ombudsman, etc. Of course, if you work in one of these organisations, then we are very happy to always be available to you for secondary consultations. If you just want to pick up the phone or send me an email and have a chat about a particular matter that you're dealing with, then we are delighted to do that. But if you are a member of the public, then please, we are really, really running on the smell of an oily rag, and we would ask that you contact our telephone information service, and they're those phone numbers up in the top right corner. And of course, whoever you are, we would love you to join with us on social media, connect with us, so that you stay updated with any further updates that we might be publishing over coming weeks and months. So thank you very much for attending. Amanda, do we have anything that's popped into the chat box?
We do, Gab. We've got a number of questions here, so I'll just read them out to you, and some of them do go back to some earlier slides as well. So the first question is, if the employee fails to follow a lawful and reasonable directive, if there is no government mandate, would you see that this gives rise to summary dismissal, that is without notice and possibly forfeiting her long service leave?
So no, if the question is saying there's no, in an example where there may not be a, I'm just going to go back to this little table because I hope that it's helpful for everyone. So if the example is there is no Chief Health Officer direction in place covering a particular worker that you're dealing with, but their employer has in any event issued a direction that the worker has to be vaccinated by a certain date, and that worker is, sorry, Amanda, is the question saying the direction is lawful and reasonable?
If they fail to follow a lawful and reasonable directive, yeah. Yes,
okay, so even if there's no Chief Health Officer direction in place, but you do agree that the direction, that the employer's direction does seem to be, on the face of it, on the evidence, it seems to be a lawful and reasonable direction, then basically what the employer is going to be arguing is this is misconduct, possibly gross misconduct, but gross, there is a difference between misconduct and gross misconduct. So I don't want to, of course, without knowing more about the case, I don't want to say that it will necessarily amount to gross misconduct. An employer can only go ahead and summarily dismiss an employee if it's gross misconduct, okay? And when there is gross misconduct and it is a summary dismissal, that's when the employer is justified in not giving notice or paying in lieu of notice.
Great, thank you, Gab. We've got a question here around what about an inherent requirement that you are able to attend the workplace in order to do your job?
An inherent requirement that you must attend the work. So the employer is saying it's an inherent requirement of your job to be vaccinated if you want to attend the workplace. And then what? Sorry, Amanda.
That's the end of the question, really. Rosa, if you're able to pop in a bit of a clarification on that question, we'll come back to that.
But if I've understood, I mean, just to, yes, in short, if the employer is saying this is an inherent requirement of the job that you must be vaccinated if you want to come back to our premises, for example, whether it's an office or whatever it is, whatever the setting is of the workplace, if it's outside of home, then I'm not here to tell you that just because your employer might be claiming that it is an inherent requirement of the job, that you've got to accept that. What I'm asking you to do always, and that's why I've given you these 3 columns here, is to turn your mind to these issues. Now, your employer might be arguing that it is an inherent requirement of the job, but remember that we've had conflicting cases on this issue, and certainly the Fair Work Ombudsman seems to be suggesting on their website that in many cases it will be difficult for an employer to successfully argue that it is an inherent requirement of the job. Okay, so yes, there has been a decision where and that's been upheld on appeal, that it was an inherent requirement of a job to be vaccinated, but in other cases that employer argument wouldn't necessarily succeed, so you do need to consider it. Okay, I'm not telling you that you have to just accept whatever the employer is telling you.
Great, thanks, Gab. We've got a question that's just come in that I might actually skip to straight away, just because it's really interesting. We've received a few calls on the TIS about this recently. And the question is, can an employee argue that they have natural immunity if they present with a positive antibody test? So, for instance, they've had COVID in the past.
Yes, well, look, that is a very interesting question, and thank you for raising it. There is, in fact, if I've understood correctly, you're not supposed to be vaccinated for, I think, between 3 and 6 months following COVID. So if you've been infected with COVID, then you're not going to be able to be vaccinated medically, and then I think you would be able to go to your medical practitioner to get evidence that there is a medical contraindication in that circumstance. Okay, but of course you need to talk to your medical practitioner. I'm not a medical practitioner, but it would seem to me that that's what I'd be doing, and I think that's what my reading of the Chief Health Officer's directions indicate that. Well, look, there is also, I should mention that there is also an exception about if you are self-quarantining at the moment. But if you're self-quarantining is a little bit different to the question, I believe, because I think the question was about what if you've already had COVID, or what if you've got COVID at the moment. And that's why I'm saying, look, you'd have to speak to your, if you're planning to go back to work and your work is going to be outside of your home, then there'll be a good reason, presumably, for why you can't get the first jab by the relevant deadline. And I believe that will fall within the medical contraindications exemption, but you'd have to speak absolutely to your medical practitioner, and you'll have to get the evidence from your medical practitioner to give to your employer. The other thing that I just mentioned was, if you are quarantining, if you're well, do you only quarantine if you have a COVID positive case? If you're quarantining, which now I'm thinking, what would the reason for quarantining? You might be you might be in isolation. I might be getting the terminology mixed up. I beg your pardon, everyone. But I'm thinking, what about if you're quarantining for 14 days, not because you've had a COVID case, but because you were a primary contact of someone? So of course, in those circumstances, you wouldn't be able to get the COVID vaccine, but you'd still have to show your employer that you have, if you fall within those prescribed categories, that is, I'm talking about if you fall within one of the definitions of worker who has to be vaccinated by a certain date, according to the directions, yes, you'll have to then still give proof to your employer that you've made a booking for the first jab. I hope I haven't confused everyone. I hope that's clear.
Thanks, Gab. We've got a question about the Natalia example, where the example says that she doesn't want to get the vaccine due to her religious beliefs. But since the direction came from the Chief Health Officer, can she still argue that the employer's directions are in potential breach of the AD Act? Shouldn't she challenge the Chief Health Officer's decision instead? AD Act.
Well, look, I'm here to talk about employment law, and so that's about your relationship with your employer and what claims you might have against your employer. And remember that in terms of this second column that I've listed here, I've always said that just because there might be a public health order in place, or just because there might be what the employer is saying is a lawful and reasonable direction, doesn't mean that you don't need to consider the things in the third column. So of course, absolutely, there's a public health order in place. That's what your employer is trying to rely on, but still, they've still got to make sure that they are complying with all our anti-discrimination laws across states and, that apply across Australia. And they've still got to be complying with any requirement that they must consult with you.
Thank you. I'm very conscious of time, so we might just do two more. And we've got a good one around consultation. So regarding what constitutes consultation, would providing an opportunity for employees to express views prior to the employer announcing its policy be regarded as sufficient consultation? This is for an employer where most of the employees are not workers who must be vaccinated under the government directions. The employer is saying that the requirement to be vaccinated is only because the government says you can't attend the office unless vaccinated.
So look, I'm not going to get into exactly what does or doesn't constitute consultation, because it is very fact specific, and it really does require you to go back to the wording. Where does the obligation on the employer to consult come from? You've got to identify the document. Is it an enterprise agreement, for example, or is it an award, or where does that obligation come from? Find it in writing, read it many times over, and you probably will get your answer then. But if you're still not sure, then of course, feel free to give our telephone information service a call. But bear in mind that our telephone information service is not able to give you legal advice, okay? We are here to give you information. It's very tailored information. We take you through all the laws that cover your specific situation. We'll tell you what to look for and what all the issues are. We'll explain how all your options work, but ultimately through that telephone information service, we're not there to give you legal advice. So if you feel like you've read and reread that consultation clause several times over, and you still feel like you do need legal advice about it, not general information, but legal advice, then you need to book yourself an appointment with a lawyer. And you might be able to do that through a community legal centre within your particular geographic location, or contact the Law Institute of Victoria to get some names and numbers of employment lawyers that might be able to give you advice. And of course, if you're a union member, you should be contacting your union to have a chat about that, and to get some guidance from your union about whether or not your employer has consulted properly.
Thanks, Gab. And just for our final question, this is really one around information privacy. So if a worker refuses to supply proof of vaccination, is there, that risk to that worker that the employer may have a valid reason to dismiss them because they don't want to share that medical information? Yeah, so the obligations on employers asking you to provide this vaccine information, remember that it's not across the board. It doesn't apply to every single employer in our state. It only applies to employers of those specific employees that I've gone through. So that's the first point to note. It's not a blanket requirement for all employers. So if your employer has asked you for your vaccine information, the first thing you've got to be thinking about is, are they actually required to do this because of the Chief Health Officer direction? Because not all employers are required to do this. If your employer is not required because of the Chief Health Officer direction, then of course you are entitled to go back and ask some more questions of your employer and to say, look, I don't feel comfortable sharing this information. Can you tell me what you're relying on in asking me for this information? Have I answered that question, Amanda? Yes, I think so. Thank you, Gab. And thank you everyone for attending this Lunch and Learn webinar session. I do note there are a couple of questions that we didn't manage to get to, but kind of glancing through them quickly, I think Gab covered off on the content of most of those in slides following the time that the initial question was asked. Now, we will be sending out an email to all registered attendees in the next hour or so, which will contain a short survey link. Please do complete the survey. We love to hear your feedback. If you do have further questions that we didn't manage to get to during the session, please feel free to just reply to that email and ask your questions that way, and we'll try to get back to everyone as well. This session was recorded, and we will be making the recording available more generally, so keep an eye out for a link to that recording as well. I think that's it. Thank you everyone for joining us, and have a lovely rest of the afternoon.
Thanks everyone. Bye.